Good morning, colleagues. Thank you for attending and a warm welcome back to the Poker SA Panda Virtual Presentation Series. We'll commence with a short presentation lasting about 30 minutes, a question and answer session of 10 minutes, and conclude with a lucky prize draw for a take-a-lot voucher worth R1,000. You are welcome to field questions in the chat box during the presentation, which will be answered at the end. We had over 500 registrations for this session, so some colleagues are still coming in, and please note that the webinar is being recorded and will be put up on our Poker SA website for those who are unable to join us now. This morning, our guest speaker, Thabo Masombuka, will enlighten us on a trending and very interesting topic, the impact of changes in the preferential procurement regulatory environment on economic empowerment and transformation, following the Constitutional Court judgment of the 22nd of February 2022. Our guest speaker today, Thabo Masombuka, is an economic transformation practitioner and advisor. He is an admitted attorney specializing in commercial, construction, and engineering contracts, procurement law, and PPPs. A former CEO of the Construction Sector Charter Council, a transformation empowerment industry executive authority, he is a community and stakeholder facilitator with unimpeachable credentials in the areas of the BBEE fronting investigations. An accredited BBEE facilitator, compliance, governance, and risk management specialist, he is also a renowned dispute and community resolution facilitator. He is currently the CETA board member and chairs the Governance and Strategy Committee there. Thank you, Thabo, and welcome.
Good morning. Good morning, Ayanda, and good morning to your participants. Thank you very much for the warm welcome. I now need to start with the most difficult fourth IR segment of portraying the screen, and please confirm with me if it's now open on the tray.
I think it's still loading, so we'll just give it a few seconds.
All right, thank you very much. Whilst the screen is opening and sharing, let me take this opportunity to thank your organization in the wonderful work it's doing around procurement, administration, and management. You will, is it now showing?
Hi, Thabo. We're not seeing your presentation just yet. If you could just click on the share button and then just select the screen where you may see a visual of your presentation. It's possibly on your second screen.
Okay.
Thank you. I'll let you know when we see it.
Let me open share.
No problem. These things always work until we're in front of an audience. Don't worry.
And if you come to think that we did a run dry just earlier on.
I know, right? And it went perfectly.
Thabo, I will just present your presentation for you.
Will you be able to do that?
There we go.
Yes,
we can
there
see
it
Aya's
is.
screen. Perfect.
Are we now on the screen? Yes, thank you very much. Colleagues, this is me briefly. Aya has done the introduction. No need for me to re-emphasize. Is now the presentation focus visible to everyone?
Yes, it is.
Yes.
Thank you very much. So we will talk briefly about the dawn of the Constitution in the country and to what extent it has introduced the principle of equity and equality and how that has factored in the procurement dispensation. I will then talk to you briefly about the Constitutional Court judgment, which involved the Minister of Finance and AfriForum, the Afri Business Unit of Business Unit of AfriForum, and what should the National Treasury has done subsequent to that, and which is most importantly the last question on whether or not universities are affected by this procurement regime. Participants will recall that since 1996, when the Constitution was introduced in our country, it introduced at least 3 fundamental principles around equality: that everyone in this country is treated equally before the law, but that equality includes the full and equal enjoyment of all rights. These rights include economic freedom and economic participation. So I'm always quick to point the fact that it's important for people to realize that you can't talk about equal rights unless you talk about economic freedom. But lastly, the Constitution introduced what is now called the state can no longer unfairly discriminate directly or indirectly against anyone based on any of the grounds listed in the Constitution. But I there have to emphasize unfairly discriminate. So logically, it does mean that the state can discriminate, but it needs to do that fairly. And I'll explain what that means. This is a most favorite slide that I have that depicts almost in no uncertain terms the importance of the constitutional equality clause vis-a-vis equity. Because a whole lot of people make the mistake of thinking that BEE, transformation, all other interventions of the state are in fact a reverse of apartheid and racism. I am quick and often haste to say, no, that's not the case. And you'll understand it when you look at this slide. This slide tells us...
I'm so sorry to interrupt. Your slides seem to have gone. I'm not sure if Aya has lost connection. I'm just trying to get a hold of her. If you can just bear with me for just a second while I sort this out.
Okay. Let me go back to... Okay, open tray. Is it now fine?
No, we're not seeing your slides yet. I'm just trying to get a hold of Aya. I'm not sure if she lost connection. I'm just trying to get her back online. Just bear with me one moment.
Okay. You know, the goodness of virtual engagement is that it saves us time, it saves us all sorts of logistics, and it's more convenient, but it also has got its own weaknesses and disadvantages.
We've got Aya, and she's just trying to present again. Just bear with her one moment. And we're back. There we go. Thank you so much for your patience, everybody. Thabo, you can continue. Thanks so much. Thabo, sorry, you're on mute now. If you can just unmute your microphone.
Thabo, please unmute your microphone.
There we go. We've got you.
All right. So I'm asking who's sharing now. Is it?
I am. Thabo, you're on mute. Can you please unmute your microphone?
All right. Am I audible now?
Perfect.
Correct. I was saying we are on the next slide. The one that depicts the equity versus equality. Are you there?
Yes, we are.
All right. Well, I'm still seeing the dawn of the 1996 Constitution slide. But what I wanted to say that slide represents quite fully the difference between the importance of letting people be on an equal footing before they can compete. Maybe I should close the sharing on my part. Yes, I've done that. Do you want to move to the next slide, Aya? All right. So the dawn of the Constitution in terms of the Section 217 meant, colleagues, that Section 217 then accelerated the importance of public sector procurement that should be used as a mechanism to facilitate economic transformation. This section is supreme in terms of public procurement because it says the state organs, when they contract for goods and services, they must do that in accordance with a system that is fair, equitable, transparent, and cost-effective. We now know what that system is. It's the PPPFA, Preferential Procurement Policy Regulation. But it also says that in doing so, the state must do what is called allocation of contract pursuant to the protection of categories of persons who were previously disadvantaged by unfair discrimination. But more importantly, it says there must be a national legislation that is put in place to facilitate that so that people don't do it from a thumbsuck. If we go to slide 6, you will know that there was a constitutional court I spoke about in the first slide. So this constitutional court happened some few years ago, starting in Pretoria, right? So what had happened is that when the Minister of Finance at the time introduced the 2017 PPPFA regulations, some unhappy litigants went to court and challenged the minister in the High Court, declaring that the period of public comment was not enough. The High Court had then dismissed the matter, but the matter went straight to the Supreme Court of Appeal. And when it went to the Supreme Court of Appeal, the Supreme Court of Appeal held that regulations 3B, 4, and 9 of the 2017 regulations were unlawful due to the fact that there is interconnectedness between the regulations of 2017 and some aspects of the PPPFA. Then, in respect of that, the Ministry of Finance appealed the decision. And the decision went straight to the Constitutional Court. And in February this year, the Constitutional Court, in a divided judgment, I must say that it was a divided judgment because if you understand how the Constitutional Court works, you will know that for a matter to have what is called legal substantive clarity, it means that the court has to be unanimous. But in this case, it was divided with a majority slim judgment, which held that the minister didn't necessarily have to have the powers to introduce what is called preferential regulations because the powers were already in existence nonetheless. So in other words, the Constitutional Court confirmed the ruling of the Supreme Court of Appeal and rendered the regulations null and void. What does this therefore means? This meant that the National Treasury had to either issue guidance to state departments and organs of state about what needs to happen. But what we saw is that the National Treasury on the 25th of February issued what is called an instruction note, which was later revised to an advisory note. It therefore said that all tenders advertised before the 16th of February must be stopped, and that tenders advertised on after must be held in abeyance, and no more tenders must be advertised. This rendered the public procurement space into disarray. Yet the court actually said organs of state need to develop their own authority and powers to issue regulations. So in other words, there was no need for the National Treasury to go into a panic mode. But because of the various incapacity of various state organs, this happened. Where to now? You will note that according to the National Treasury, there was a new draft regulations 22, which were issued and closed on the 11th of April. This means that in the short to medium term, these will be reviewed for public comments, and we know that the National Treasury is currently processing those comments, and then this will be introduced to induct and orientate the state of organs in their various capacity in terms of how to move forward. Participants will remember that there's also what is called the Public Procurement Bill that is before Parliament. This Public Procurement Bill is meant to replace the PPPFA in its totality. We are hopeful that the Public Procurement Bill will take into account all these developments and ensure that there is clarity of purpose going forward. Our interesting questions: are universities then organs of state for purposes of this PPPFA? Well, you will realize that organs of state are defined in terms of the Constitution. Section 239 of the Constitution defines an organ of state as any department or administration in the national, provincial, and local sphere that performs a functionary, that exercises a power in accordance with the Constitution or in accordance with an act that enables it. So are universities established in terms of the act? Yes. Are universities performing a public function? Yes. Are they administrating certain powers? Yes. However, so to the extent that they do, then this means that certain pieces of legislation will bind universities as public institutions, right? These include, but they are not limited to, the promotion of access to justice. It means that everything must be done procedurally in a lawful administration matter. Per Buddha, which is the Promotion of Equality and the Prevention of Unfair Discrimination Act, the Bill of Rights, and the many other pieces of legislation will be binding on universities. However, universities are not organs of states for public procurement purposes because the PPPFA was meant to administer the money that is allocated to institutions in terms of the PFMA and the MFMA. So if the PFMA and the MFMA does not apply to universities, it therefore means that the PPPFA will not apply. So what this means is that universities are not governed by the PPP.
Sorry, I just want to come in there. Can you just let me know which slide you're on so that the audience can keep up as well while you are speaking?
Okay, I'm on slide 12.
All right, thank you.
I'm on slide 12, which now deals with whether universities are organs of state for purpose of PPPFA. And the issue that I'm saying is that universities are not governed by the PFMA, therefore they are not expected to comply in terms of the PPPFA. They can use their own procurement processes. However, and here's an important however, on slide 13, that notwithstanding, universities are still organs of state for purpose of other public function, but universities are still public institutions, universities are still corporate institutions, universities are still centers of power. So therefore, they've got all stakeholders and people interested in their procurement outcomes. So it means they are not absolved from fairness, procedurally and substantively. They are not absolved from transparency. They are not absolved from equal protection and advancement of people with historical disadvantage designation. So in other words, in all the procurements that universities do, in all the procurements that public institutions do, they must always consider Black people, Black youth, persons with disability, rural communities, because it is their economic constitutional responsibility to do what is called economic redress and advance equality before the law. So Thank you very much. This is on slide 14. It's more an end of the presentation, and then we'll be able to entertain any questions in the next 10 minutes that we left with Aya. Thank you very much.
Thank you, Thabo. Colleagues, we will now proceed with the question and answer session. We will just be fielding some questions that are in the chat box to Mr. Masombuka to answer.
Thank you so much. Thabo, I'm having a look at the questions. I see there's quite a lot of conversation going on here. I see that we've got a question here that says, how can government function and deliver services due to this regulation being declared unlawful? Surely some emergency powers can come into effect, or old PFMA regulations should be in effect to enable government to continue functioning? You're on mute at the moment.
Thabo, please unmute your mic.
You're still on mute at the moment. If you can just click your microphone button there. There we go. Got you.
Thank you very much. I think the question is precisely about efficiency and effectiveness.
Oh, you're on mute again. Sorry, I think that might have been a shortcut key or something. There we go. Back again.
Yes. Can you hear me now?
Yes, we can. Thanks, Thabo.
I wanted to say that.
It's happened again. Sorry, Thabo, you're on mute again. I'm not sure what's happening there. Something's could be a shortcut key. You can just click your mic again. There we go. Got you back again.
Yes, I think it keeps on going back. It's on a
technical gremlins this morning. Yeah, it's on again. Something's wrong with your microphone. I don't know why.
Okay, can you hear me now?
Yes,
can you hear me now?
Hear you again. Yes, thank you.
Yes, I wanted to say the question is spot on in terms of the importance of efficiency and effective administration of procurement. Government cannot afford to be in what is called a crusading mood. Government cannot be able to idle because decisions must be made on a daily basis at a local government, provincial government, and otherwise. So what is happening is that with the constitutional judgment having rendered the procurement of 27 invalid, it didn't really render the content of the procurement. It rendered the powers of the minister to issue this. And there is a difference. It is the powers of the ministers that they didn't have to issue, but the content of this still remains. So what this means is that going forward, organs of state must develop their own policies that are sector specific. So in agriculture, organs of state there must take into account the transformation and procurement realities there. In ICT, in health, in education, in aviation, all these various organs of state must be able to then take into account their sector specific priorities and needs in rolling out procurement. But there's a rider. They must do that to the extent that this is not inconsistent or in conflict with Section 217 of the Constitution around transparency, fairness, openness, competitiveness, cost effectiveness, and taking into account historically disadvantaged communities.
Yes, yeah. And what about, I see there are questions here about TVET colleges. I mean, are they, I mean, organs of state? No, they're not, right?
Well, there's still a debate of thought there in terms of whether or not. But remember in the slide, the way I spoke about the importance of being an organ of state. You are an organ of state if you are established for a public purpose. Are TVETs established for a public purpose? Yes. Are you set up in terms of a piece of legislation? Are TVETs set up through a piece of legislation? Yes. Are you receiving public funding in terms of the PFMA? Are TVETs receiving money on their own, fundraising on their own, or are they receiving money from the state through the Department of Higher Education and Training? The answer is yes. Therefore, if you receive money in terms of, all of your money in terms of the public fiscus, you must be audited by the Auditor General of South Africa. Therefore, when they come, they're going to ask you questions how you procured, and you must have procured in terms of the PPPFA. There is, however, some debate on whether or not TVETs are in fact organs of states or not. But for a purpose of this, we will leave it there until there is clarity. But based on the logical flow of reason, TVETs should in fact be organs of state because they receive money and they spend in terms of the PFMA.
Right. That's quite interesting. And what about, I think there's a lot of unanswered questions and people are wanting to know how long this court case is going to go on for.
The court case is done and dusted. The court case was issued on the 28th of February. The National Treasury was waiting to understand whether there is a suspensive clause on the judgment on whether or not can this effectiveness be suspended until later on. There is no clarity there. It means as things stand, organs of state need to develop their own procurement policies with their own targets based on their specific, following the constitutional ruling. We are hoping that the National Treasury will provide guidance, directives, because that's what the National Treasury can do. It doesn't mean that the National Treasury needs to administer PPP procurement, because that's what used to happen previously. And this used to incapacitate the state in various organs. So what this means is now going forward is that organs of state must start to take responsibility for their own decisions. As long as they are guided by the Constitution, they are guided by fairness, they are guided by openness, they are guided by transparency, they should not be scared of taking the right decisions. Because the reality is that the priorities in aviation are not the same as in agriculture. The priorities in ICT are not the same as in transport. So you can't have a one-size-fits-all procurement legislation. Procurement legislation must talk into specific, in mining, in Mpumalanga, in the Northwest, in the Northern Province, communities are complaining about lack of procurement opportunities there. And all organs of state, which is a DMR, they must then intervene based on the mining conditions and issues of communities there. They can't follow what is happening in Free State or what is happening in Natal. It's wrong. And it is not subscriptable to logic.
Yeah.
I see there are more questions.
Yes. There's another question here that says, should universities proceed with the advertisement of bids as long as they're following their own internal supply chain policies and procedures?
Correct. Universities should be able to do so because universities, like I said, are not affected by the PPPFA, are not affected by what is happening out of the National Treasury. By and large, they are audited by own private audit firms who are going to come and check whether or not they followed the principles that I outlined. Fairness, openness, transparency, procedurally and otherwise. So your SCM procurement policies must speak to those values. And as long as the universities take into account that there are constitutional imperatives in this country, so that every rand they spend must at least account to the extent of transformation and the procurement in those communities that it is procuring from. I think it's very important that universities do that.
Okay. I've got another one here from Jason Roberts saying, can a university elect to exclude bidders as part of the pre-qualifying criteria phase that do not hold a BBBE certificate?
So universities can use their own criteria. They can exclude bidders. They can include bidders depending on what. So for instance, what universities will seek, like any other organization would do, they would develop what is called a procurement plan. So your procurement plan will tell you that in the past 5-10 years, we've been sourcing certain services and goods from these categories of providers or suppliers. Now, we then need to increase and expand our supplier database, for an example. We need to invite tenderers from these categories of communities. having regard to the priorities that I set out in the light slides. In the light slides, we're saying Black people, Black women, because you can look at your procurement spend over the past 5-10 years and say, in all our air conditioning services, for an example, we have not had any supplier from this category. So you can then draw a procurement plan based on what you currently and historically been faced with. Then you can use that to determine your new requirement. And as long as you can justify that, look, for all our IT services, in the past 5 years, we've never had Black women and youth, for instance, as service providers. You can then justify to set out new targets and exclusionary grounds to say, now we want to do what is called equity and redress and ensure that we have a balance in our code. As long as you do that based on a plan, a procurement plan, that is realistic, that is reasonable, that also give open opportunity to all, because in your, remember, once you have a plan, you're going to advertise it to all your suppliers, you're going to distribute it, you're going to invite them for objections if they have any, and they must give reasons. Remember, they can't come and say, yeah, your plan is exclusionary because it's racist. And as long as you are able to say this plan is exclusionary because we are implementing fair discrimination because of our historical spend, and then you are justified under no circumstances. No AfriForum, no any other institution can take you to court and succeed as long as you can show that all that we're doing is based on the values and inscribed in Section 217 of the Constitution.
Okay. All right, we've got one here, just it's actually about municipalities. So Edward here is saying, as organs of state, do all municipalities have to adopt one tailor-made procurement solution, or can a metro, like the city of Cape Town, issue their own specific procurement regulations?
The impact and implication of the Constitutional Court judgments decentralizes the power and the authority of organs of state. Remember, organs of state can be found at national, provincial, and local government. Assuming to follow the question's logic, the city of Cape Town can follow their own procurement, but there's always a catch in this. Although it gives discretion and the power to these organs of states, the Constitutional Court said they can't be willy-nilly in their power. They have to always follow the values entrenched in Section 217. And Section 217 has got 3 sub-steps. The first sub-step is that if your procurement policy is going to be tested on whether is it fair, is it open, is it transparent, and is it cost effective. And if you pass that test, it goes to the second. To what extent is it taking into account people of historical disadvantaged communities who are unfairly discriminated? And if you can't support that, then it means your procurement will fail. And more lastly, is it supported and based on a national legislation? And there are many such legislation. The BE Act, for instance, is one of those legislation. If your procurement policy does align to BE in terms of what you practice, for instance, an organ of state can say all our bidders for our cleaning services, our cleaning contracts, must have a BE level 3. It will do that because it is justified in setting that requirements, because it will say, for the past 10 years, for the first 5 years, we've never had a BE level 3 being in our contract or facility management contracts. And if you set those requirements, you will obviously be excluding BE level 4s, level 5s, level 6, but you have basis of doing that. You are not thumbsucked what you've done. And the Constitutional Court does provide that discretion, but that discretion must be exercised judicially, objectively, and fairly.
Okay, thank you. I've got one here from Nonhlanhla, which sounds quite interesting. She says, thank you, Thabo. Some universities have selected to use the PPPFA in the past, 80-20 or 90-10. How do we then come out of it without going through the National Treasury and ask for exemption? Interim arrangement, while that's in brackets, she's saying it's an interim arrangement, while the universities are looking at their own processes that replace this piece of legislation.
Well, remember the 80-20 and the 90-10 principles or pre-qualification criteria was set to separate functionality from price and technicalities. So universities can still use that, but to the extent that they then set the other requirements either as pre-qualifications or as the conditions to enter into the procurement pool or the shortlisted pool. So in other words, universities don't need to go to the National Treasury for any form of exemption, because in the first place, they are not affected by the PPPFA. So they therefore don't need to go to any form of exemption. And that means if you are not following the PPPFA strictly, it means there is no compulsory requirement to follow the 80-20 or the 90-10. Can be 60-40, can be 70-30. Universities can set their own criteria based, again, on the pool of their database, on the priorities of their procurement spend, because there's always this, if you look at your procurement spend, if your procurement spend is 50 million, for instance, and on an annual basis, it's always 50 million. You always have to present to EXCO, to the board, or to the council and senate, how you have spent your procurement over the past financial year. You break it down. On our procurement spend, so much went to people of color, so much went to technical suppliers, so much went to young people, so much. So once you break down that procurement spend, it will tell you already how your focus have been, and you can able to transform that spend based on what you have spent over the past few years. Your past few years always inform your current plan and your future.
Okay. And then Kumbuzile says, as Nonhlanhla mentioned, some universities apply the PPPFA and PPPE in their procurement processes. How are they excluded from the ruling? Presume he means the ruling that you've been referring to.
I think if some universities are applying the PPPFA, which I argue they shouldn't, because there is no obligation on their part. So it means that the ruling doesn't really, it affects them to the extent that it affects all other organs. So in other words, it would affect, as it would affect Transnet, PRASA, it would affect ESCOM, it would affect,
SOEs, basically.
SOEs in particular, yes. So if there are any new sort of guidelines, new directives that are issued subsequent to the public comments, universities will also have to follow those. But like I said, there is no obligation on universities to follow the PPPFA as long as they are able to demonstrate that their processes are based on fairness, openness, transparency, and cost effectiveness.
So, I mean, what I'm hearing here is that this isn't really for our members, for PERCO's members, because it's the universities and the TVETs. The PPPFMA.
The PPPFA, yes.
Yes.
So here's a difference. There's a PFMA, which is your Public Finance Management Act, that regulates how you spend the money, the processes, and the procedure. So, for instance, you can't use money budgeted for toilets and use it for air conditioning, for instance. And if you have to use over a certain amount, you must get a directive or approval from National Treasury, all sorts of things. We've seen the SAA, how it used to be reined in terms of the PFMA.
Yes,
so then
sorry,
I meant the
PPPFA. Yes.
Then the PPPFA says the preferential procurement process of doing that must be based on, depending on the value, 90-10 if it's above $1 million and so, and 80-20 if it's less, and that procedure must be followed. So the one that's been set aside is the one that used to say a pre-qualification criteria must be for all BE compliant companies who are 51% Black-owned. It used to set aside the 30% subcontracting. It used to set aside the localization. It used to set aside the importance of rural women and people with disability. All those things now have been put aside because of the Constitutional Court judgment. However, organs of state can continue to infuse those things, because as long as they can justify that those things are linked to their sector priorities, meaning they are based on the realities and the concerns faced by the suppliers or which are in their database.
Okay. I've got a question here from Samantha, she says, when do you foresee Treasury completing their questionnaire in order to advise government on the way forward and take the hold off of all procurement over 30,000 Rand?
So the closing date for public comments was on the 11th of April. So it means the 11th of May was a month old and we're almost on the second month. Usually, because of all the submissions, the approvals, the minister's signature, we should be able to see the new look directives. And I don't call it the procurement regulations because the court said they can't do that. They don't have the authority to do that. So we'll see new directives, new guidelines coming out sometime at the end of this month or at least before the end of June, because the longer it takes, the more uncertain certain organs of states are in terms of what they need to do. And remember, a whole lot of organs of state do that because they have capacity limitations, and most of them don't even have the internal staff to comprehend and understand the implications of these judgments and these rulings and these guidelines. So if you were to ask me, I think before the end of June, we should be able to get guidance and communication on what organs of state needs to do in order to comply with the Constitutional Court, but in order to give effect to their own powers that they already have, by the way.
Yeah. Okay. And then Lisa asking, she says, Thabo mentioned that the court judgment was done and dusted. So why do organs still delay the award of tenders?
I think it's because the National Treasury told them to do so, issued the clarification note that I spoke about in slide 4 or 5, if I can remember. So that's why a lot of them have sort of discontinued, issuing tenders and administering those. But I think, and this is where I spoke to various sitters, I spoke to a number of other organs of state. I went to the State-Owned Enterprise Procurement Forum, which is a forum that represents various state organs and SOEs, procurement officers and executives. I spoke there and I explained that there is no need to discontinue procurement. You see, there's a fear factor existing in this country, but precisely because people are scared to make decisions, either because they don't know how to make the right decisions or they don't know how to motivate and support the decisions they've made. And they always rely on the National Treasury to tell them what to do and guide them what to do. It shouldn't be the case. As I said, as long as your procurement is based on a procurement plan, is open, transparent, fair, cost effective, and it's supported by the constitutional imperatives of Section 217 on the historical disadvantaged persons, you have no reason to worry. So people are doing that because firstly, they are scared. Secondly, because they don't know how to justify and support their decision. But the issue is, if they could do this support and support their decision, they should have no reason to even hold on to any of their procurement decisions.
Yeah, I'm sure that's very frustrating for a lot of people who are attending today. I'm not seeing any other questions for this session. Is there anything else that our audience wants to ask about this session? Thabo can spend a few more minutes with us if you do have more questions. Otherwise, if you do think of something after this session, here's a question. Edward is asking, what is the Auditor General's view on this issue?
I haven't heard what the Auditor General said. They haven't issued any statement in respect of the judgment. But what I do know is that the responsibility of the Auditor General is simply to audit public money. Okay? So wherever you spend, and if you spend in accordance with your policy, because you remember, when auditors come to your organization, they just say, show me the proof. That's all they want, remember? Show me the proof. If you have spent 500 Rand, you spend it in terms of what authority, and as long as you can justify. That's what the Auditor General focuses on. I know that there has been engagement between the National Treasury and the Auditor General's office. We were looking forward to hear more on that. But I do know that this Constitutional Court judgment supersedes everyone. And if the Constitutional Court judgment says this cannot be done, you cannot have, because I know the underlying part of this question is that what if I'm an organ of state, I continue to procure according to what the Constitutional Court judgment says, and the Auditor General comes and make negative findings? They can't, because you would be guided by what is before you in terms of policy, in terms of a decision. As long as you involve your accounting authority to make the decisions, all organs of state have got accounting authorities, they've got ExCos, they've got management, they've got a board. Yeah. And the board takes final accountability for every decision. Okay. Thank you very much.
Makes sense, yeah. I've got one here that says, will this misunderstanding of the ruling not exacerbate corruption? Misunderstanding of the ruling.
It is a scary part, but it is a very, I'm telling you, it is a very scary part and a very legitimate question.
Okay,
because let me be honest with you, thieves thrive in confusion, okay? Thieves thrive in confusion because they know that no one knows what needs to happen. It's like when you are looking for a black cat in a dark room, then someone comes in to pickpocket you in the process, in the midst of that. So there is the real concern about thieves. But remember, in this country, theft happened even when the regulations were still intact, even when there was no constitutional court ruling. So what needs to happen is that organs of state needs to watertight their systems. All you need to do is just to put in place systems, have a procurement policy approved, and that procurement policy implemented to justify decisions made. Of course, we cannot, you cannot do away with thuggery and theft, but all you can do is to mitigate it, and you can only mitigate it to the extent that you put in place systems that are checks and balances that are able to justify decisions being made. Currently, I'm reading a number of fronting, unlawful, illegal award of various tenders by municipalities, by various organs of state, where they have flawed processes, where they have contravened procurement policies of their own to give preference to certain. The good thing is that more and more unhappy bidders and suppliers are now starting to take these matters to court, because that's what should happen. If you feel that you've been unfairly done by a procurement outcome, first in terms of prior, you need to write and request information that affects you as a supplier, but more importantly, then take up decisions to the nearest court of law, so that it must be ventilated, so that those who make decisions must prove that they did that openly, fairly, and transparently. Let me tell you, if you've been committing theft and illegality, you can't pass the test of fairness, you can't pass the test of openness, transparency, and justifiability.
Yeah. I've got one from Patrick here that says, even though this gives public entities freedom to apply their own policies, is it your view that it opens them up to a lot of audit findings?
It is not my view. My view is, in fact, that this thing should have happened a long time ago, and there would have been precedent by now. Had the National Treasury not taken over procurement through the PPPFA regulations of 2017, we would not be here where we are now. So in other words, this centralization, this nationalization of procurement through the PPPFA regulations, in essence, created two things. One, it created overindulgence and over-reliability, okay? Where organs of state can't say anything because they are scared of what the National Treasury will do or say. And in the process, that incapacitated their organs of state to do things their own way. So in other words, and I know this from a fact because I worked at the DTI for many years, and we used to have difficulty relating to other departments and organs giving them transformation and BEE directives, and they would not listen to that until the National Treasury puts that in writing. So yes, if they do things themselves, and if they do them wrong, inconsistent with their own policies, their own plan, they will be open to audit findings. But if they do it in accordance with their own processes, own plan, there's no reason why they should be open to audit findings. Thank you very much.
Thank you very much. I mean, this has been an excellent Q&A. Thank you so much, Thabo. Sansa is getting a question in there just before we leave. I think this will be the last one. So can the PPPFA regulations of 2011 be applied until 2017 regulations are finalized in terms of the ruling? But I think you've already kind of said that it's finalized.
I have said that it's finalized. Thank you very much.
Cool.
However,
so that answers that.
Yes, I'm sure Aya would share the slides with a number of participants who have seen that you have. And on the last slide, there are my details there, an email address. People can directly engage me if they think that what I said is hogwash, or if they think that there is a better understanding of this. And let's engage. Look, this is part of the national discourse to change the face of public procurement in the country. Thank you very much.
Thank you, Thabo. I'll hand over to Aya now. Thanks so much.
Thank you, colleagues, for a very engaging question and answer. We will now proceed with the lucky prize draw, where one of you will walk away with a 1,000 Rand Take-A-Lot voucher. And the lucky winner is Marizan van Rensburg, the technical assistant at the Central University of Technology in Free State. Congratulations, Marizan. A Take-A-Lot voucher will be on its way to you shortly. So, like I said, thank you, colleagues, for a very engaging question and answer session. And in conclusion, I'd like to thank Thabo for sharing his knowledge and insights with us. And thank you very much, colleagues, for attending, and goodbye.